All right, well, after some microphone issues, we are now live. I'm going to give a second for people to come over here and I will share the link on um, the old video so that people have that. All right, we're going to wait just a second here. I will be talking, but I want to give an opportunity for people who were on the previous live session to come over and join this one. We had some technical difficulties. It was my fault. I had an audio setting at the wrong level. And so we're going to give just a moment for folks to come over here. Today is one of these warm, sunny days in Minnesota after 6 months of cloudy days for the most part, or really cold days. This is a delightful time of year. I love doing hikes, walks with my wife and 4 daughters, bike rides, love going to northern Minnesota, whether that be International Falls or Grand Marais, Silver Bay, Duluth, Tetagooch State Park, Gooseberry Falls. It's just this next 5 or 6 months, it's just going to be beautiful. So we are getting that time where we are about to start live. So we'll transition here, and I have my assistant. He's helping out with comments. So feel free to put your questions in the comments section. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurial companies. I'm located in the Minneapolis, Minnesota area. And today we are doing this live Q&A so that we can answer questions that are on the minds of business owners throughout the world. I do need to give a couple disclaimers though. First, this is educational content. It's not legal advice. What does that mean? It means I'm not your attorney. Think of me more as a professor where you're asking an academic question. Specifically, I'm not licensed in your jurisdiction. I don't know your state laws if you're outside of Minnesota. I don't know your particular circumstances. And in this sort of forum, I don't have the opportunity to ask you important questions to understand your circumstances. But you also don't have to pay. You're attending this YouTube live for free. And so the best questions that I can ask are more academic or educational questions. We don't have time to dive into the details of someone's circumstances, analyze it. And also, it wouldn't be appropriate for me to give private, confidential legal advice in a public forum like this. So keep that in mind too. Everything that is put on this YouTube channel, including your comments and questions, it's public. And what goes on the internet likely stays on the internet forever. So keep in mind that these topics that we discussed today are going to go on YouTube and they'll be publicly available. So please don't put any uh, personal information, confidential information, or anything you don't want out there. But I do love your questions, and I love answering questions that help empower business owners to prevent problems, to resolve problems, and to know what kind of issues and questions should you raise with your attorney. One of the challenges I had in leading a law firm was attorneys are trained to analyze the law and solve legal questions. But you know what? In law school, very rarely is there any training about working with clients or understanding client goals and understanding how businesses work. Um, in the medical field, they call it bedside manner. Have you ever had a doctor come over and maybe give you all the right answers, but it wasn't really thinking about what was important to you, the feelings, the emotions, the goals, and the concerns that you had? Well, likewise, I often see that attorneys can err on the side of technical resolution of the law without thinking about the practical aspects. Why do I say that? Because one important part of this live presentation today and the other videos on this YouTube channel is to empower you to identify the legal issues and questions to raise with your attorney. So if your attorney doesn't bring it up, at least you are empowered with the information to bring it up. All right. So those who are here today are probably here because you subscribe to this YouTube channel, and great to have you a part of this community. I'm really happy you're here. That means you get notifications when we're going live. And so it's wonderful to have you here. Another group of people are here because you follow us on some other social media channel. And really happy to have you here. Feel free to add comments in the section below. You can also submit questions in advance. You can do that by emailing me or otherwise getting a hold of my office. I will say, though, questions presented live get first priority. So if you can present them live and be present, that's wonderful. That's just a way that we can reward those who attend live. You also might be here because you have subscribed to our mailing list. And a number of business owners have subscribed, and here's why. They got the 7 most common legal mistakes made by new businesses and how to avoid them. That's a free handout that we give out. Again, no charge. And then it's followed by videos answering some of the common questions related to those areas and helping educate business owners on how to avoid those problems. So if you haven't subscribed yet, you can go to aaronhall.com/free, sign up there. It's a great way to continue to get education to empower yourself as a business owner to avoid common legal problems that destroy businesses or at least waste money, attention, and resources. All right, we're getting into the questions here today. Without further ado, let's jump into the first question. Should you avoid service of process? Well, what is service of process? That's when you're getting sued. Somebody's trying to deliver legal documents to you. And usually they need to at least attempt to deliver them to you in person. That means somebody needs to come up and hand them to you or put them on your doorstep. So should you try to avoid that? What does that look like? Well, you see somebody that you don't know coming up the sidewalk. They ring the doorbell. You duck down below the couch. You wait to see what they're doing. Maybe you peek out the edge of the window. Maybe you have somebody else in your family peek out the edge of the window to see what they're doing. Maybe you have all the shades pulled, or maybe you're out of town, but your front doorbell camera picked up somebody doing something. Whatever the circumstances, you're probably wondering, should you try to avoid service of process? What are the benefits of that? I recommend you don't try to avoid it. Here are the benefits, though. The benefit is once you are served a lawsuit, the clock starts ticking and you have a certain number of days to respond to that lawsuit. So you might be able to get an additional 7 days if you delay getting served the papers by 1 week. But what benefit is that really? I mean, an additional 7 days, but how does it really matter? There's a downside though. First off, just practically, you're going to start feeling really paranoid anytime somebody you don't recognize is driving near your house or walking near your house, or maybe somebody is coming up to your workplace. You start to drive and look around corners and peek around bushes. Mild paranoia can set in. It's really stressful. So when my clients ask me about that, I say, look, let's just accept service of process. I can even do it on your behalf. It's not worth the stress of this unknown lawsuit being served. Get it? We'll figure out what it says and we'll deal with it. And besides, it's not like you can avoid it forever. You might be able to avoid it for a few days. There's another problem. If you try to avoid service of process, uh, that is a violation of the law. And it's not going to look good in your lawsuit if you try to avoid getting sued for a while and you required the other side to spend a lot of time and money chasing you down. So, generally speaking, I say just accept the lawsuit. Let's figure out what it is. And then we deal with it. Lawsuits can be dealt with, and you have plenty of time as long as you have an attorney in your corner who can walk you through that. So, I do not recommend trying to avoid service of process. Next question. How does your LLC pay you? So, if you're starting a new business, as a business owner, you might be thinking, how do I get paid? What does that look like? I've always received a paycheck. Do I start issuing a paycheck? And how do I do that if the company doesn't have money to pay me? Let's face it, most new businesses, they don't generate money right away. In fact, you're going to have to put money in to get things started, to start setting up a website and setting up the legal work and the LLC or S corporation or whatever it is. You're going to put money in before money comes in typically. So, how does the LLC pay you? First, it doesn't have to pay you. So, if the LLC doesn't have any money to pay you, you don't get paid. So that's okay. It's not like you have to borrow money to pay yourself. And besides, who's going to loan a new LLC money anyway? So, first off, you don't have to get paid. But now let's assume the LLC is making money. Let's say it has $10,000 in profits in there that it's not going to need for its ongoing operations. Those profits are available to be distributed to you as the owner of the LLC. By the way, the owner of the LLC is called a member. In a corporation, we call the owners shareholders. In an LLC, we call the owners members. So, as a member of the LLC, you are entitled to have profits distributed to you. You can also pay yourself as an employee. In general, what LLC owners do is they pay themselves a profit distribution. All they do is write a check from the LLC's bank account to their own personal bank account for whatever amount of profits they want to distribute to themselves. And what do they call it? They call it a profit distribution. So in the memo line, you can put profit distribution. So it might be from Jenny's Flowers LLC to Jenny Smith with a memo line that says profit distribution. And the dollar amount says $10,000. And then Jenny cashes that in her personal bank account. The money comes out of the business bank account and goes into Jenny's individual personal bank account. Now you might be wondering, can you just do an account to account transfer? Sure. You don't have to go through the process of writing a check. You can go ahead and just do an account to account transfer, like log into your banking system and transfer money from one account to the other. Here's the key. You'll need to keep track of this at the end of the year because profit distributions are taxable. And so you're going to pay both income tax and self-employment tax, which is about 15%. So income tax, let's say you're in a 30% tax bracket. And by the way, there's federal income tax, state income tax, if your state has an income tax, and then payroll tax. And so all of those need to be paid. As a general rule, my suggestion to business owners is put away half of the money you receive in profit distributions so that you have money set aside at the end of the year when you need to pay your taxes. Because payroll tax, state income tax, and federal income tax all add up. And generally, it adds up to somewhere between 35 and 50% of the money that came into you. There is a side issue here we're not going to get into today, and that is for an LLC, or I'm sorry, for an S Corp. we might deal with this a little bit later if people have questions about it. So feel free to add a question in the section below. But there's a separate way that you would handle paying yourself for an S corporation. And there can be some tax savings with that, depending on the circumstances. Okay, so just to kind of conclude, how do you pay yourself in an LLC? The LLC writes a check to you personally for the profit distribution amount, and then you end up having to pay tax on that at the end of the year. It's a pretty large amount, can be up to 50% or so, sometimes a little bit more, depending on your tax bracket. So make sure you set aside money for that. Okay, let's see if what the next question is, if you would. And I'll ask my, you would type this poll in the questions so people can follow along and answer it. What state or country, if it's not the United States, are you watching from today? I just love to get a sense of where people are watching from. All right, next question. Is a business required to have insurance? The short answer is most businesses are not required to have insurance, but there are some important exceptions. Let's talk about those here. So, once you have employees, state law may require you to have workers' compensation insurance so that if somebody is injured on the job, there's an insurance policy that can cover their wages. Second, states may require you to have unemployment insurance if you have employees who are not yourself. Third, some types of businesses are required under state law to have insurance. For example, some states require lawyers to have insurance. It's called professional liability insurance. And these insurance requirements are usually for what's called regulated industries. So lawyers, doctors, accountants, other healthcare providers, anyone that's required to have a license to do their work. That's where you're going to want to look at the specific rules for your licensure to see whether there's a requirement to carry insurance. The final category of insurance is general liability insurance that most businesses might consider. General liability insurance is generally not required. So, in summary, most businesses are not required to have insurance, but there may be a requirement in your specific state or industry that a specific type of insurance be carried. All right, next question. What is a non-solicitation agreement? A non-solicitation agreement is an agreement that's usually signed between a company and an employee. And the employee is agreeing that after they leave, they will not solicit employees of the company, vendors of the company, or customers of the company. What does that mean exactly? Well, let's say the employee goes to work for a competitor. And prior to that, the employee signed a non-solicitation agreement. By signing that, the employee agreed the employee will not ask employees from the old company to go to the new company, or or vendors from the old company to go to the new company, or customers from the old company to come to the new company. In other words, an employee is entrusted with the relationships of the employer when the employee comes. And the employer recognizes it would be really harmful to introduce the employee to these relationships, later have the employee leave, and have that employee then solicit the those relationships and try to take that away as well. It's hard enough for an employer to lose a good employee, or even a not so good one necessarily. But to then have other relationships solicited and brought over. Now you might be wondering, does this, if the person who signs a non-solicitation agreement doesn't solicit, but someone else solicits them, is that a violation? Let's play it out. Let's say, for example, a an employee signs a non-solicitation agreement, then goes to the new employer, and one of the vendors from the old employer reaches out and says, "Hey, we would like to serve you instead of your old company." Or maybe it's a customer of the old company reaches out to the employee and says, "Hey, can we continue to work with you at the new company?" Is that okay? You might be thinking, well, it should be okay because there was no solicitation by the employee who transferred. But usually or non-solicitation agreements say it doesn't matter who initiates the contact. It's not just solicitation. It's also any other efforts to take away business from the original company. It would also be any other transactions or engagements with a new company. And typically there's a period of time, like 2 years, for example. Now you might be wondering, are non-solicitation agreements enforceable? They generally are, yes, in virtually every state, if not all of them. And you might be saying, but wait, I heard that non-solicitation agreements are not enforceable in some states, like California, for example. What you're probably thinking about is a non-compete agreement. So let's talk about the difference between a non-solicitation agreement and a non-compete agreement. So let's set the stage. What is the difference between a non-solicitation agreement and a non-compete agreement? A non-solicitation agreement says a person will not take relationships to a subsequent company. We're talking about the relationships that were introduced and they won't be carried over. That's non-solicitation. By contrast, a non-compete agreement is where a person cannot compete. They cannot actually do business in an area. Typically, it's geographically limited, so it might be a 10-mile radius from the former employer, or a 100-mile radius, or a 100-mile radius from any of the former employer's business locations. Are non-compete agreements enforceable? In many states they are. In fact, in most states, but not all states. For example, a non-compete agreement between an employer and an employee generally is not enforceable in California. Why did I say between an employer and employee? Because there can be non-compete agreements between other parties. For example, let's say I start a business. I sell widgets throughout the United States. And I've built a lot of great relationships selling widgets, and maybe I even sell those widgets on infomercials. And then I decide to sell my company to a new buyer. And the buyer says, "We'll pay you $1 million for this business, but you need to agree not to compete with us for 10 years. We don't want you starting a brand new business, competing somewhere else and under a new company. And now all the people who recognize you start to associate that goodwill with the new company." So they have me sign a non-compete that for 10 years I will not start a new business that competes with them. That is enforceable in virtually all states in all circumstances. Why? Because it's from a seller of a business to the business and to the new buyers. That's very different from employer to employee non-compete agreements, because with employer and employee, there is a bargaining power differential. In other words, the employer has a lot more bargaining power, the employee has a lot less. Whereas with a buyer and a seller of a company, there's usually much more similar bargaining power. Also, I just think legislatures in states are more concerned about protecting employees who are generally considered more vulnerable and susceptible to being taken advantage of than business owners who are selling their businesses. Let's face it, most people, when they sell their business, they have lawyers involved. They have protection. They know what they're walking into. A lot of times, employees don't know what they're walking into. They didn't go to law school. They might be quite young when becoming an employee. So there are a number of states now that are either outright banning non-compete agreements or having significant restrictions on them. Right now in the Minnesota legislature, there is legislation going through that would prohibit non-compete agreements in the employer and employee relationship moving forward. So those that were signed in the past would still be in place, but moving forward, they'd be prohibited. Okay, so non-solicitation agreements, that has to do with relationships. They're enforceable. Non-compete agreements, that has to do with competition in the marketplace, just the ability to do business. That is viewed with scrutiny by the courts and not enforceable in some states. All right, we have an interesting question here related to something that happened in the news just last night. Last night, former President Donald Trump was found liable to E. Jean Carroll for defamation and sexual assault, but was not found liable for rape. So here's the question. If Trump repeats to the public that he did not sexually assault E. Jean Carroll, can he be liable for defamation again? So here's the scenario. President Trump, or the jury found that President Trump did sexually assault E. Jean Carroll. And he said falsely that he didn't, which implied that she's lying and had, under defamation law, has a suggesting somebody is a liar has a tendency to reduce their credibility, their reputation, their goodwill, etc., financially harming that person, especially when it's done in such a public way as we saw here. So the jury already decided that there was sexual assault and Trump defamed Carroll. So if Trump says again that he did not sexually assault her and that she's lying, could he be liable for defamation again? Absolutely. Absolutely. And here's why. He's doing again just what he did before, and he was found liable for doing it before. Now, there would have to be another case, and there would be some different legal arguments. First off, we'd have an argument about whether the prior jury's decision could come in. Trump's lawyers would argue that it's not relevant to whether he defamed her, and Carroll's lawyers would argue it is relevant because he knew it was false. He was previously told this. He'd already been reprimanded for this. He already was found liable. That information should not be withheld from a jury. Trump's attorneys would make a number of arguments saying, look, it's not relevant to the new set of facts, and this new jury should have a right to come up with its own conclusions. So that's kind of a new twist in that second lawsuit. There'd also be an argument over how much damages there were. In other words, if Trump already paid 5 million, let's say, in damages to Carroll for the first defamation, did the second defamation really cause much more harm? In other words, the public already had all the news that Carroll won the first case. So, to some extent, that um, bolsters her reputation and undermines Trump's. Second, Trump already paid $5 million for the damage that occurred. Carroll would have to show that there's been additional damage beyond that 5 million that took place. So, to summarize, if Trump repeats that he did not sexually assault E. Jean Carroll to the public, he makes public announcements. Can he be liable for defamation again? Yes, because he is defaming again, assuming that that is how the jury would have a similar finding in a future case. Okay, we're going to move on to the next question. It's getting warm in here today. It's heating up outside and the sun is glaring in on the window. All right, quick question. Why are lawsuits so expensive? Quite frustrating. When I was first involved in politics and government, shortly after high school, I thought to myself, justice should be swift. Our founding fathers talked about how quick justice should be. It shouldn't drag on. There is such a problem in the court system with the fact that these cases go on for a year and sometimes many years. People have a right to get resolution to their issues promptly, not delayed over time. So, why are lawsuits so expensive? It's because we put, as an American society, we put justice as more important than efficiency. Because let's face it, let's say you had a trial that happened a day after, or let's say a week after a lawsuit was started. On one hand, that would be really efficient. That'd be great. The lawyers couldn't bill $100,000. There's only 7 days in a week. And the parties who are in the lawsuit would have finality. At least we'd have a court decision in that case. But here's the problem. Would there be justice done? Would the parties have had time to gather all the evidence, interview all the witnesses, and prepare those witnesses and the evidence for trial? No, you can't possibly do that in a week, especially in big cases. Imagine there's 100,000 documents, or imagine you have to get emails off an email server at a company, which takes time just to get them. Then you have to review them. Then you have to see how they're relevant to what individuals knew. Then you ask those individuals questions. You might have depositions to do that. Then, once you've gathered all this information, you might even find out that there's more information out there. Like, oh, there are a few cell phones that will have information that were deleted from the email server. We need to go get that. So you can see how this goes on. This is called discovery. It's where the parties are discovering information. You need to have some time to do that. And then the parties need to have time to process it and put together their arguments and address legal issues prior to trial. And those are presented to the judge in the form of a motion. Then you need to prep for trial and go to trial. And by the way, there should never be surprises at trial. I love the surprises that happen at trial on TV, but that's called ambushing someone, and it's generally prohibited in real court systems, not on TV. So everything needs to be exchanged well in advance of trial. The parties exchange all the evidence, the list of witnesses, and many times what those witnesses are expected to address. Then finally, you prepare for trial, you coordinate schedules with everyone, and you have your days of trial. So that's why, in general, lawsuits do need to take somewhere between 9 months to a year. Now, you might say, well, I know a lot of cases that take a lot longer than that, and they're a lot more expensive than that. That's true, but that's usually because one party is trying to find a lot of things to fight about. There's a lot of money at stake, and everything involves lawyers doing a lot of work. So, for example, if you're talking one of the big oil companies or big tech or something like that, or a class action case, that's going to take a significant amount of time. So, why are lawsuits so expensive? Well, every single stage of this effort needs to either be done by you for free. In other words, you don't have to pay yourself, so you save money from hiring an attorney, or you hire an attorney. If you hire an attorney, the attorney is spending hours doing all of these things, gathering the information, reviewing it, meeting with you, putting together arguments, writing up those arguments for the court, presenting them, waiting for the court to rule, maybe having another motion to the court, presenting those arguments, waiting for the court to rule, coming on back. You might have many motions prior to actually getting ready for trial. In fact, it's very typical to have motions, and a motion itself can cost $5,000 to $10,000, and that's fairly common because you need to present all the arguments so you don't lose. You can't just say, "Oh, it's the judge will get it. The judge will understand." No, you have to present the arguments for the judge to consider, and then the judge can adopt those arguments in the order. So unfortunately, with these motions, both parties have to respond, and it takes time and it takes effort and it takes investment. And if you're hiring an attorney, it takes an attorney to do that. If you're doing it on your own, not only is the quality going to be much worse, but you're going to be trying to figure out the law as you go. And when we take into account attorneys have gone to 3 years of law school, plus then typically a number of years practicing under a senior attorney to learn, you're trying to get a lot of that learning relevant to your case in a very short amount of time. By the way, did you know that many attorneys don't go to courtrooms? They're called transactional attorneys. They'll just tell you, I don't litigate. I don't go to the courtroom. Why? Because they may know the topic of law, but there's a whole different set of rules and laws related to how things are handled in the courtroom. There's a set of rules called the rules of evidence. There's a set of rules called the rules of civil procedure. There may also be other rules like the rules of general practice. Then individual districts may have their own rules, and individual judges might have their own rules. And so that's why not even every attorney is willing to go into a courtroom, which makes it just emphasizes the amount of information that needs to be learned and processed and applied if you're trying to represent yourself in court. There's an old saying, an attorney who represents himself in court has a fool for a client. Why? Because even attorneys need attorneys, somebody who can see objectively and represent them without the emotions and the distraction of the narrow perspective that the person has. You need somebody who's objective and can think about what does the judge need to see. All right, so that's a long way to answer why are lawsuits so expensive. Let's see, what is the next question here? Can you recover attorney's fees if you win a case? In the United States of America, the general rule is no, you cannot recover attorney's fees if you win a case unless a contract says you can or a statute says you can. So we start with the premise that you cannot recover attorney's fees if you win a case. But there might be a specific statute addressing your scenario, or if a contract that you signed says the winner can recover attorney's fees, then it can. So that's how you figure out if you can recover attorney's fees. A related topic is this. Will all attorneys work on a contingency basis? In other words, the attorney doesn't get paid if the attorney doesn't win the case? No, not all attorneys will. And in fact, most areas of law, attorneys will not work on that basis. Let me give you an example. Let's say you are charged with murder, just to pick a simple example, and your attorney representing you wins. Well, who's going to pay the attorney if you win? The government doesn't pay that. You'd have to pay that. So it's not like a scenario where there's a car accident. An attorney sues the insurance company of the negligent driver, and the insurance company pays out money, and then the lawyer typically would keep a third of that, and two-thirds go to you. That's a different scenario because money is coming in. But in criminal offense, there's no money coming into you. You're just fighting for your freedoms. And the attorney, you can't pay the attorney a third of your freedoms, for example. And in fact, contingencies are prohibited as a matter of law in a number of areas, including criminal law, also generally divorce law. Think about it this way. You don't want attorneys incentivized to help a couple get divorced, because if it's not in the best interest of the client, we don't want the attorney pushing for their own money and their own self-interest. We want the attorney to be devoted to the client's best interest. Now, does that always happen? Absolutely not. And in fact, I think it's very unfortunate that attorneys have a self-interest to fight, because the more they fight for their client, the more money they get. And so they get paid more by fighting more. Thus, attorneys have a self-interest to fight more. It takes a noble attorney, an attorney with integrity, an attorney who puts the client first, to say, I'm only going to fight if it's in the best interest of the client, and I'm going to work with the client on that. Now, a cynic might say, well, an attorney can't fight if it's not with the support of the client. That's true. But I've found a number of clients who have been so angry with what happened to me, or what happened with them, that they have said to me, I would rather pay the money to you as an attorney than let my, spouse get it, or ex-business partner get it. And there are probably a lot of attorneys who would say, this is great because I could use the money, you know. And I think that's really disgusting and sad, because you have a person who is at a very vulnerable, delicate time in their life, looking to the attorney for counsel and advice about what they should do. And so it is even more important that the attorney put the client's interests first. Otherwise, the attorney is violating their fiduciary duty of loyalty. They are breaching the trust that the client has placed in them. And I just think that is a great injustice. And I am highly sensitive to that, because I have seen too many times over the years where attorneys are acting in their own self-interest and taking advantage of clients. So I think when a client comes to an attorney and says, I'd rather pay you than the other side, it's a proper response is the following. Thank you. I appreciate the trust that you place in me, but I have no desire to put my own interests first. We need to put your interests first. And I understand right now you are very interested in preventing this other party, who has done a lot of awful things, from getting your money. But I also want to think about more than just the money. I want to think about the distraction this case could be. Because, by the way, we're probably talking about whether to settle and pay some money. And I tell my clients, let's put some value on the distraction, the negativity, the toxic nature of this lawsuit, and how it affects your happiness in life, your contentment, your peace, perhaps your other relationships. What do I mean? Many times when people are in the middle of a lawsuit, they're talking to their friends and family about it because they're so outraged. They can't believe what's going on. And these friends and family get, first, they're sympathetic and empathetic, but after a while, they're like, we're kind of, this is taxing on the relationship. And so it's important for my clients to understand that a lawsuit not only will tax their own happiness and their own peace of mind, but also their relationships. If a business is involved, often it affects the lawsuit affects the morale of the employees in the business, especially if they're getting deposed. So there are great consequences and negatives to continuing a lawsuit. And often it makes sense for parties, even though they don't want to settle and it feels unjust to settle, if you can pay a small amount of money and be done with that thing, that often is better for the client than continuing to slog through the toxicity of litigation. All right. Um, let's move on to the next question. Is an NDA the same as a confidentiality agreement? Yes, it is. NDA stands for non-disclosure agreement. It says that you won't disclose confidential information. That's the same thing as a confidentiality agreement. They're the same thing. These are just titles. What does matter is what's in the document. But you can have two confidentiality agreements that are very different. You can have two NDAs that are very different. But whether you call the document an NDA or a confidentiality agreement is really irrelevant. It's just a title. It's like whether you use the word contract or agreement. They're synonyms of each other. It doesn't matter which one you use. Both of them are the same. All right, let's take a look at the next question for today. Okay. Let's talk about defamation. What are your options if someone slanders you? So defamation is when somebody says something false against you. And by the way, it needs to be a false fact, not a false opinion. So it's when somebody has a false fact that is said to another party about you that has a tendency to reduce your reputation or your esteem in the eyes of others. So let's say, for example, John said that Sally is a jerk. Well, is that defamation? And let's assume Sally is not a jerk. She's actually a very pleasant person. In that case, that is not defamation because jerk is an opinion, it's not a fact. Now, if John said Sally is a child molester, that's a factual statement. Assuming she's not, that is defamation. Let's say John said Sally sells apples. Is that and Sally doesn't sell apples. Is that defamation? No. It may be false. In fact, it is false in this scenario. But it is not the type of factual statement that has a likelihood of reducing someone's reputation or esteem in the community. So, if somebody defames you, like they slander you, or they engage in libel, what are your options? I'll give you an example. Somebody posts something online about you that's false. You can ignore it. You can issue a public statement about it, saying that it's false and kind of calling them to account. You can send them a cease and desist letter telling them to cease and desist defaming you and to remove that comment that's posted online. Or you can sue. You can do all of those. You can do some of them. You can do them in the order that you want. They're all available. If you sue, you have two options. You can sue for damages at the end of the lawsuit, or you can sue for both damages and an injunction. An injunction is the same as a TRO or restraining order. It generally means the same thing. Technically, it means different things in different places, but most people consider them the same. An injunction or a TRO is basically telling somebody to stop doing something illegal. And instead of a letter, a cease and desist letter coming from a lawyer, an injunction is ordered by a court. So if the person violates the injunction, they now have problems with the judge, and they're accountable to the judge for violating a judicial order. Much more serious consequences. The consequence of violating a cease and desist letter are you might get sued. So, what are your options if somebody defames you online? Ignore them, call them to account, send a cease and desist letter, or sue them. All right, we're at 11 o'clock. We've covered all the questions we have time for today. Love to have you at a future live session. If you'd like to know about these, and by the way, they're usually not available in full online unless you hop onto them live, then you can watch them. But if you would like to be part of the next one, feel free to register at aaronhall.com/free. You'll get on our free newsletter. Doesn't come out that often, and it's all about delivering important value to you, educational information that will help you avoid problems in your company and improve your life. Go to aaronhall.com/free if you would like to get notified about the next time we are going live. It was wonderful being here with you today. Please feel free to check out this YouTube channel and subscribe if you are interested in other educational information for business owners to bring more success to your company and life. Have a great day.